The dog is snoring, you're just going to have to deal with it, but welcome to First Amendment Auditing Urban Legends. Today we're going to talk about something that is near and dear to me. You may have heard that badges don't grant extra rights. Well, it turns out cameras also don't grant extra rights. This is Brandsburg v. Hayes, 408 U.S. 665. This is from 1972. If you're wondering why I haven't picked out a more recent case, it's because the Supreme Court hasn't really touched on this issue in the last 40 years, so there's nothing new to report. In this particular case, newspapermen were resisting subpoenas to federal and state grand juries. And the court held the publisher of a newspaper has no special immunity from the application of general laws. He has no special privilege to invade the rights and liberties of others. So the newspapermen were not allowed to ignore the summonses, subpoenas, etc. How does that relate? Well, just as they can't ignore the laws in regards to summons or subpoenas, they also can't ignore the laws as they relate to trespass. Take, for example, Section 30.05 of the Texas Penal Code, criminal trespass. This is a video by Mexican Padilla. Mexican Padilla is a fairly new First Amendment auditor. He went down to a local post office with friends. They were conducting an audit in the parking lot. The police were called. When the police showed up, one of the officers claims that he recognized Mexican Padilla as having been trespassed the previous day. That officer went into the post office. Mexican Padilla followed him. The officer went into an office where he presumably was talking to the station chief or whatever they call him, a supervisor. And Mexican Padilla then took the opportunity to film in the lobby. This is what transpired next.
Go ahead and turn your camera off. You're going to be placed under arrest for trespass charges, okay? You were warned about this yesterday
You need to fuck off
or
and get
last
off me.
week. So, I tell you what, let's go and take this
Don't touch
outside.
me, bro.
Come with me.
Don't touch me, bro.
Come with me.
Don't touch me.
You're ready for dispatch. Can you get a couple of units headed my way?
Not against the law to record in public, sir.
All right, I think that adequately expressed it. It's not against the law to record in public. Well, yes and no. This is poster 7 from the post office. Photographs for news, advertising, or commercial purposes may be taken except when used by public, or except where prohibited by official signs or security force personnel or other authorized personnel, yada, yada, yada. Other photographs may be taken only with the permission of the local postmaster or installation head. That is based on 39 CFR 232.1, subsection H5I, photographs for news, advertising, or commercial purposes, except as prohibited by official signs or the directions of security force personnel or other authorized personnel, yada, yada, yada. Other photographs may be taken only with the permission of the local postmaster or installation head. Now, whether or not it is a news, if it is for the purposes of news, that is a question of fact that the finder of fact, which would be the jury, or in the case of a bench trial, the judge, would determine whether you went there for the purpose of gathering news. Most likely, the judge or the jury will not find that you were there to gather the news, but rather you were there to make the news, which is an entirely different thing. But any way you slice it, if security force personnel or other authorized personnel say that you can't film in there, you can't film in there. That's what that whole except as prohibited means. It means you can film for news, advertising, or commercial purposes, except as prohibited. I don't know why that's so hard to understand, but it appears to be beyond the ken of a lot of people out there. And no, 148G doesn't apply in Texas. Criminal trespass, this is what Mexican Padilla was arrested for. Or was, yeah, what he was arrested for. He wasn't charged with it. A person commits an offense if the person enters or remains on or in property of another without effective consent, and the person had notice the entry was forbidden or received notice to depart but failed to do so. So the officer believed that he had noticed the entry was forbidden. The officer may have come to question that. Notice that notice means an oral or written communication by the owner or someone with apparent authority to act for the owner. This is an operative word. Apparent authority doesn't mean that they need actual authority. It just means they need apparent authority. So if somebody walks up to you and says, yeah, I'm the supervisor, you need to leave, that is notice. That is effective notice for the terms in terms of this penal code. That would be notice. You would have notice at that point for the purpose of 30.05. Now, if it's oral, that means that there can be some question. Was it actually delivered? They don't have any proof that it was delivered unless they had it recorded somehow or in some way. But I would bet you a nickel, a shiny brand new nickel, that if it was Mexican Padilla, who they did trespass previously, and if it was oral notice, assuming arguendo that the officer was correct in that, they didn't have any way of proving that. So they didn't have any good way of showing that he had noticed the entry was forbidden. Now, if you remember when the officer came out of that room, he said, you're under arrest at this point for trespass. So he wasn't giving notice. He was arresting him. If I'm assuming that's why it quickly changed to a written trespass warning, because once it turns into a written trespass warning, then the police have all the details. It was pretty obvious that they have his date of birth, his full name, including proper spelling. They have his driver's license. I mean, they know it's him at this point. So if they ever respond to another trespass call at that post office for him, he's not going to have any way of saying that he didn't know that he wasn't allowed to be there. So I don't know if it's a huge win for him that no charges were filed. If charges were filed, he could have challenged the constitutionality of 39 CFR 232.1. But I guess maybe he gets to try to win on the 1983 suit. Anyway, thank you for watching. Please don't copyright strike me, and have a great night.